Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here.
Oh, okay.
What your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other. When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm going
to little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay?
Yes, ma'am. I'll take care.
All right, everyone, buckle up because today's video is a full-on roller coaster through 5 different courtrooms, 5 different defendants, and 5 completely different versions of I don't recognize your jurisdiction. From veterans of sovereign ideology to fresh recruits still fumbling their legal buzzwords, this episode has it all. We've got a man who negotiated probation without an attorney, another who tries to sue a judge mid-hearing, and even a mother who tanks her own custody hearing just to make a point no one asked for. If you've ever wondered what happens when confidence meets confusion inside a courtroom, this is your case study. So grab your popcorn, hit that subscribe button, and let's dive right in.
The city, state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer to send us back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in a motion. I don't have to put it in a motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm
trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those
It's not a
positions.
debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're.
And right there, we already see how these hearings go sideways fast. The judge is calmly offering to appoint an attorney, but this defendant insists he never had one, never needed one, and somehow still managed to plead guilty to a felony without representation. That's not self-reliance. That's self-sabotage. What's fascinating is how many sovereign citizens refuse legal help because they believe lawyers are part of some imaginary system they don't consent to. But when the court starts reading statutes and violation terms, suddenly they realize consent isn't optional in a courtroom. Clip 1. Notice how the judge keeps giving him every possible chance to do things by the book, appointing counsel, explaining bond, setting dates, but he's still resisting at every step. This is a perfect example of how sovereign citizens mistake choice for control. He thinks refusing to sign paperwork keeps him free from jurisdiction, but legally, it just freezes his case. What do you think? Should judges be this patient, or should they just remand defendants who refuse to cooperate immediately? Let me know in the comments below. Clip 1. So that's our first sovereign out of the way, a man who thought skipping probation was a loophole instead of a violation. Spoiler, it's not. But now we move from delusion to defiance. Meet Albert Hicks, one of the most combative, self-proclaimed legal experts we've ever seen. This guy doesn't just reject the court's authority. He tries to overrule the judge from the defense table. Get ready for a clash of egos that turns a hearing into a verbal boxing match.
Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to talk? You really want to do this? All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we've set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates? I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to.
Here's where the fun begins. Albert Hicks declares himself his own attorney, a favorite phrase among sovereign citizens who think watching one YouTube video on common law makes them bar certified. The judge immediately calls his bluff by asking for his P number, the unique ID assigned to licensed attorneys. And of course, Hicks doesn't have one. What's brilliant here is how the judge keeps his composure, knowing exactly where this is headed. It's like watching a teacher let a student finish their wrong answer, just to prove a point.
What is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction. And jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant.
At this point, you can almost feel the tension vibrating through the screen. Hicks keeps demanding proof of jurisdiction while threatening Title 18 lawsuits. something sovereigns love to do without understanding what Title 18 actually is. The judge, though, doesn't flinch. He's asserting authority calmly but firmly, giving Hicks every rope he needs to tie his own argument into a knot. And here's the real irony. The more Hicks talks, the stronger the record against him becomes. It's courtroom theater at its finest, except the audience is a jury that won't be impressed by legal fan fiction.
Incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice.
And now we reach the crossroads moment. The judge offering Hicks two simple options. Take the plea or face a jury trial. Instead of choosing, Hicks argues about his constitutional right to a bench trial, which doesn't exist the way he thinks it does. This is the sovereign citizen paradox in a nutshell, demanding constitutional rights while misunderstanding the Constitution entirely. What's wild is that the judge still offers him due process, even after multiple outbursts. That's professionalism under pressure if I've ever seen it.